I was saying that social and personal circumstances can difficult both this access in a material sense and the possibility to have a proper answer from courts to their request, citizens' request. The incapability to understand equality in material terms is a factor that may contribute to create distance between our public services of justice and the people in whom sovereignty dwells. We need gender equality, rights of people with disabilities, child-friendly justice, and other equalitarian perspectives to provide us with tools to interpret the law in a way that allows a fair treatment to everyone. That is the reason behind the Istanbul Convention, the Convention on the Rights of Persons with Disabilities, or the Council of Europe Strategy for the Rights of the Child from 2022 to 2027, amongst other rules that have implications in the way we, in the courts, assist people. What we want to do during this conference is to reflect on the best practices to achieve an inclusive and equalitarian treatment to all people, despite their circumstances. Many decisions may be beyond our acting or decision capacity. For example, we may have no possibility to participate in decisions about how court buildings must be, but we should know how to best assist citizens to run their rights in their access to the courts, no matter if they have a physical or intellectual disability, are in risk of social exclusion or even socially excluded, or simply without taking into account their age or cultural level. Europe is sensible to this point, and luckily many of us have boosted initiatives to improve an equalitarian and inclusive attention to people in courts regarding the role of judicial training in this matter. For example, here in CEG, we have included as one of the training axes the one appointed as equality, inclusion, and fight against gender violence, in which development we have published this year our first training plan of equality, inclusion, and fight against gender violence for prosecutors and court staff mainly. It also includes the open activities that we offer to anyone who is keen on these subjects. This training plan is the main result of the strategy we have designed and developed the last 2 years to attack all the gaps that citizens may find in their access to a material justice. So to start these reflections, we count on 4 companions, 3 of them members of EJTN steering committee, whose generosity has led them to share their experiences with us. Thank you very much to all of you. And now I'll introduce them, starting with Gianluca Grasso. Gianluca is member of the board of directors of the Italian School for the Judiciary since January 2020. Previously, he held several positions in the Judiciary, and the last one was judge at the Documentation and Study Office of the Court of Cassation and trainer of the Italian Judicial School in the Supreme Court. From 2015 to 2020. He's member to the EJTN Steering Committee, the Law Council, the Youth Board of Governance, and have a degree in law. Thank you very much for participating in the table, Gianluca. Second, on my right, is Wolfgang Limberger. Wolfgang Limberger is prosecutor at the Prosecutor's Office at the Higher Regional Court of Vienna. Has a law degree with specialization in economics, gender, and diversity management. He's currently seconded to the Austrian Ministry of Justice, where his focus lies on developing and strategic diversity management, as well as the training of judges, prosecutors, and court staff in diversity and criminal matters. He represents Austria at EJTN as national contact point and is member of the working group programs. Thank you very much, Wolfgang. On my left, I have to introduce you, although, well, you all don't need introduction, but I have to do that. Jean-Philippe Rageade. Jean-Philippe Rageade. No. Jean-Philippe joined the Academy of European Law, the ERA, in March 2005, and has been the director of the Academy since January 2021. It has been the project manager and the project advisor of nearly all large-scale EU training projects implemented by ERA over the last decade. He also represents ERA in the steering committee of EJTN and is a member of the European Commission's expert group on European judicial training. Thank you very much. And last but not least, Katharina Steininger. Katharina Steininger is first instance judge with experience in family law and adult guardianship. She has a wide professional trajectory, which includes important collaborations with the EJTN on topics related to human and fundamental rights, and specifically on the attention to cultural diversity in the courtroom. She has recently been seconded to the Austrian Ministry of Justice, where she deals with the preparation of legislative acts in the field of material criminal law and represents Austria at an international level. Thank you very much for being here today. Well, and now I have the structure of the round table. I'll make you some questions. We have a short time, but we'll manage it. I'll ask you a first question. We'll try to do the second one. And I will really try to arrive to a final question common to all of you. Let's see if it's possible. We'll try to. Well, Gianluca, we'll start with you. The Scuola Superiore della Magistratura, the institution trusted with the training of the Italian judiciary, is strongly committed to the theme of fundamental rights as part of the initial and the permanent judicial training programs representing the fil rouge of the school's courses catalog. In the context of the 6-month Italian presidency of the Committee of Ministers of the Council of Europe, the school decided to explore a new approach to the topic of training on fundamental rights. Can you explain why you arrived to the conclusion that it was necessary to innovate in the way training on fundamental rights and attention to the vulnerable was being designed?
Muchas gracias, Abigail. Considering the topic of diversity, I will also try to choose a different language, so to speak in French, for just to combine also on the linguistic point of view diversity. Comme ça, alors, bonjour, mesdames, messieurs. Alors, c'est un plaisir pour moi d'être ici pour mettre en commun la dimension de la formation des droits de l'homme, des droits fondamentaux. Et alors, on est parti dans considération la situation du juge et du procureur dans ces temps, c'est un peu comme la personne qui est dans un labyrinthe, on peut dire, non? Parce que la société est certainement très complexe, et aussi les besoins de la société, mais aussi les règles. Ce n'est pas seulement une question des règles nationaux, il y a un contexte européen, surtout des droits de l'Union européenne, mais surtout encore de la Convention des droits de l'homme. Et alors, le problème, c'est comment assurer une formation spécifique au juge et procureur pour donner la vie de sortie de cette labyrinthe. Ça marche?
No, it's okay.
Bien.
I can follow you, but I prefer to have the...
Chercher de donner la possibilité, les fils pour sortir de cette labyrinthe. Alors, l'école a fait une réflexion parce que certainement les aspects sont très complexes. Il faut avoir pas seulement des règles de législation, mais aussi la confrontation avec un système de jurisprudence qui est plus typique du common law plutôt que du civil law, non, la jurisprudence de Strasbourg, mais aussi la jurisprudence de la Cour de Luxembourg. Et alors, considérant aussi plusieurs condamnations qui avaient arrivé sur le plan de Strasbourg pour l'Italie, on a bien pensé de choisir des arguments très spécifiques où il y avait des critiques sur le plan de l'italien interne, par exemple la violence contre les femmes, ou l'adoption, ou les droits de visite des enfants, et aussi la prison, les conditions de santé des prisonniers et des détenus. Et alors, on a bien pensé de créer des laboratoires, des ateliers très spécifiques, ciblés, avec des problèmes, en prenant toutes les personnes qui sont dans les sujets partout d'Italie. On choisit un juge, un procureur spécialisé dans les domaines du séminaire. Mais faites attention, parce que juste à ce moment, on avait seulement des cours généralistes qui peut participer n'importe qui. Personne peut demander d'aller là-bas. Mais dans ces cas, on demande au chef de cour d'envoyer une personne de chaque cour d'appel spécialisée dans ce domaine pour discuter, pour faire des discussions ciblées, tout dans la même chambre, sur les sujets spécifiques des critiques, avec des experts du niveau de Strasbourg, avec des experts nationaux. Après, on met toutes les personnes dans une chambre, on fait des sessions, des discussions très intenses, ils sont tous spécialistes du sujet et peut-être ils sont représentatifs de toute l'Italie, y compris la Cour de cassation du parquet général de la Cour de cassation. Et à la fin, on arrive à avoir un output, c'est un rapport spécifique qui souligne pas seulement les aspects critiques, mais aussi les bonnes pratiques pour résoudre les problèmes. Parce qu'il y a, mais parfois, on ne les connaît pas aussi bien. Et aussi, il y a un échange très fort entre différentes réalités du sud au nord de l'Italie. Tout le monde est représenté dans la chambre et les personnes, quand ils rentrent chez elles, peuvent porter les contenus de la discussion. Et on partage à la fin les rapports faits par les coordinateurs, les facilitateurs, experts de l'école qui travaillent sur le sujet. Et on les envoie à tous les magistrats et tous les cours, tous les parquets. Et comme ça, il y a vraiment la possibilité d'avoir des conséquences significatives. On l'a fait au début pour l'adoption et le sujet des visites. On l'a fait avec la violence contre les femmes et aussi les mois derniers avec la prison de la santé. C'est ça. C'est une formule très simple, mais effective. Mais on continue, bien sûr, à faire des activités tous les années pour la généralité des magistrats. Mais ça sont des cours spécialisés pour certains sujets, considérant la représentativité de tous les magistrats qui sont en Italie. C'est ça.
Thank you very much, Gianluca. Sorry. Now, Wolfgang, you have detected that it is necessary not only to look at diversity in the training that our institutions offer, but also regarding our own staffs. In Austria, you have carried out a large employee survey for this purpose. Could you please explain us how have you developed this project and which are the main conclusions you have reached? Thank you.
The tipping point in Austria for pushing diversity measures was, like in Italy, criticism from the Court of Human Rights in Strasbourg. Criticized Austria the way it was dealing with minorities and vulnerable groups. To develop a diversity strategy, a working group was installed with several different stakeholders, and they identified 4 perspectives for diversity. From a fundamental rights perspective of view, access to justice, equal treatment and equal chances for everybody. From a quality management perspective, like Ingrid already said, judges without or with less prejudice helps to ensure administration of justice without discrimination. And from a human resource perspective in 2 ways. One, from a recruitment perspective, and second, from an employer duty of care perspective. So they have also developed several actions, which we have partly already implemented, like training offers, raising awareness for diversity aspects, and boosting boosting some groups that need support. We have installed a cross-mentoring program. We have installed a leadership training for young female aspiring court presidents. But the main conclusion from this working group was that for fundamental approaches for diversity, we need to know the status quo of the diversity in the justice system in Austria. We need to know how diverse are the people working in the Austrian justice system. We need to know what do they actually think about diversity, how it is perceived at courts and prosecution offices, and how do we actually deal with discrimination at the workplace in our own courts and prosecution offices. So as a result of this working group, the ministry decided to implement a strategic diversity management, where we don't set just single actions like we do now, but identify and develop strategic goals and measures to reach that goals that could be evaluated and adapted. And to develop these goals, it is key to know where we stand now and where we want to go. And that is why we decided to design and implement a unique and tailor-made survey to get data for exactly these questions. And two aspects were of utter importance when we designed this project: scientific standards and absolute anonymity for the participants, since we're asking very sensitive questions for very sensitive topics. And for this reason, we worked together with the University of Economics in Vienna. And our approach for boosting diversity is, if we can boost diversity amongst judges and prosecutors, and introduce diversity as a culture in courts and prosecution offices, we can at the same time boost the way judges and prosecutors appreciate diversity of the people that they're facing in court proceedings every day.
Thank you very much. It's very interesting because you two have given us a complementary and a holistic approach. Gianluca, in the Scuola Superiore della Magistratura, you arrived to the conclusion that there were needed innovative solutions for organizing training and so to deal with our mission as an institution. But in Austria, you also realized that we had to take a look inside. So it's very complementary, because if not, we may think we are different from the people, and not, we are the people too. And it's very interesting. Well, Jean-Philippe, ERA is a leader in the training in EU law, mentioned in the European Judicial Strategy for 2021 to 2024 as a key actor and an essential multiplier of knowledge in EU law. It has a broad experience in implementing EU co-funded projects, and is also very sensible about the necessity to assess properly diverse people at courts, despite their specific circumstances. Could you please mention us some of the current projects you are implementing on attention to diversity, and how do you decide where to put the focus?
Thank you very much. I'm very grateful to you, Abigail, for the invitation. I'm also grateful that SER came up with the idea of organizing a directors' conference specifically on the topic of diversity, which is important to all of us in general, but also very important in Spain in particular. I was invited last summer to your big conference devoted to justice at the service of the citizens. I took part in a roundtable discussion, again, with Gianluca. So, I mean, this is a common destiny. And while we were speaking, there was on this side, a woman moving arms, fingers, lips, interpreting in sign language what we were presenting. And I asked you immediately after, is this common? Is this usual? And you said, obviously. Yes, of course, it is. It was not obvious to me. It impressed me very much, I must say. And this allowed me to make the link to the first project I could mention, because some years ago, ERA implemented a large-scale project on finance by the European Commission on the UN Convention on the Rights of Persons with Disabilities, so-called UNCRPD, which is the first international legally binding instrument which sets minimum standards for the rights of persons with disabilities. It's, by the way, the first human rights convention to which the EU has become a party. Maybe there will be one day another one. And in this UN convention, this UN convention recognized actually a few things: equality, dignity, autonomy, independence, inclusion, and says basically that persons with disabilities have the same rights as everyone else. And I remember that many of the top experts we were able to find to implement this series, as well as many of the best practices we were able to identify, they came from Spain. So that's why it closed the circle, and it came from Spain, from Ireland, and from the United Kingdom. So I'm not saying that the others are bad, but I'm saying that these are three countries which are very well advanced when it comes to that. So I wanted to stress this, that Spain is a very inclusive country, and Ingrid stole me my word, front runner, that I had. Indeed, when it comes to the situation of people with disability. You stole it without knowing it, just to be clear. So, to quote Ingrid, talking now briefly about...
You're okay.
Okay, thank you. If not, you do this. So, talking briefly about current projects we are implementing on attention to diversity, I will limit myself to the most prominent examples of such projects we in the program of ERA, and which are two long-running training programs on EU anti-discrimination law and on EU gender equality law. These are topics we have covered in our program since 2003. And just three figures to illustrate this. First one, we bring together every year around 600 legal practitioners, understood as judges, prosecutors, court staff, lawyers, but also academics. 600 every year. We organize 12 seminars per year across Europe. Half of them are addressed at the judiciary, in a narrow sense. And by the end of this year, we will have contributed to the training of more than 10,000 legal professionals in the field of anti-discrimination law and gender equality. So this is a kind of passion at ERA. And we are very proud to deal with such an important topic, I must say. And I think we've been nearly everywhere, and this is a good occasion to say thank you for being so kind and hosting some of the events. The good thing is we have, and there is also another advantage, and that when being at your places, we offer all these events not only in English, but also in your local language. So which allows us to develop and to gather a huge bunch of training materials, multilingual, and indeed we have my colleagues, because I'm talking about the work of my colleagues, have been able to gather and to form a huge online library, multilingual, where, I mean, if you want to know something about racial discrimination, about burden of proof, about please go on one of these two subsites. You will find PowerPoint presentations, e-learning course, multilingual. We have it in German, French, and English, of course, but also in Spanish, in Portuguese, in Latvian. So I mean, we have nearly all languages. Ask your trainers to go there and to help you themselves. They can take whatever they want without even, I mean, if they inform us, that's nice, but there's no need because it's public information. But there is a lot of materials to make use of if you want to develop something in this area. Yes, when we speak about anti-discrimination law, we have basically in mind, of course, the huge case law of the Court of Justice, fundamental, but also the two directives, of 2000, the Employment Framework Directive, and the so-called Racial Equality Directive. So, and when it comes to here again gender equality, the case law of the Court of Justice is properly amazing, and everything the legislator, the European legislator, is to catch up what the Court of Justice is doing, because the Court of Justice is a front runner in this area. And what is interesting, it's probably a good sign or not, we'll discuss the challenge at the end.
Yes.
So that's very interesting to see how much has been developed and adopted in the last 5 years. I mean, equal pay for equal work, this directive. So work-life balance, gender balance among the directors of listed companies. This is a current one, a bit far away from our topic, but also important one. And there is a very interesting proposal, which is unfortunately very topical, but still at the level of proposal because it's complicated. It's about combating violence against women and domestic violence. Here again, maybe this is something which will be passed on to the next European Parliament. I think I will stop now. Yeah.
Thank you very much.
Because otherwise she will be. She warned me that.
No, but you are, until now, you are very disciplined, the three of you. Katharina, you have a challenge here. But thank you very much, Jean-Philippe, very interesting. And you're right, there are many different topics. We have chosen 4 of them for our workshops in the Directors' Conference, but it's not the only ones that we must face, the only challenges we must face when talking about diversity. And I remember that conversation between you and me about is it normal? And yes, it was a surprise for me because I think it happens to all of us. All of us always think that make less than what we really do. And we are very conscious of all the things we don't do here in CER, and I imagine it's in general, and we always want to do more. But when you told me that it was not as usual as I thought, well, it made me happy. I'm proud. So
one more sentence, if you allow. I don't know if when you noticed when you entered, there is a map of the building. And the map of the building is half in Spanish and half in, how do you call it, Braille? Braille. I don't know if it's like this in your institution. It's not like this in mine.
And we have an I must.
Yeah.
That it should be.
Yeah. In mine or in general?
And I must say we are improving it. We have a plan for making better installation and making it more accessible because it needs an improvement. So, but thank you very much for noticing. Anyhow, well, Katharina, now with you, you have a wide experience in dealing with diversity from different perspectives, and your work in the first instance court gave you a direct contact with cultural diversity, in which you have deepened during your career. Could you please explain us? And maybe this should have been the first question, but we're on time still. Could you explain us what do we understand as cultural diversity?
Okay, thank you for giving me the floor. So actually the question requires quite a complex answer, but I was told that I have twice the time that anybody else to outbalance the gender inequalities on this table. No, I'm just joking. I'm
watching the watch right now.
No, so my understanding of this term is the consequence of both my experience as a judge, as well as my experience as an activity coordinator of a seminar that is actually called Seminar on Cultural Diversity in the Courtroom, which is organized by the EJTN in close cooperation with the Max Planck Institute on Anthropology in Halle in Germany. And so my reflections on what cultural diversity is were strongly influenced by Professor Foblitz, who is the director of this institute, and by her team members, who actually provided us with the necessary scientific and historical background on the term of cultural diversity. And I will actually try to illustrate to you a bit like what it means to me by both taking into account this scientific approach as well as my practical experience when I was working as a judge. So as judges, we are used to applying state law. And state law is, for obvious reasons, rooted in the social, cultural, and history actually of a country. And Europe has certainly been marked, let's call it, by stormy periods between majority communities and some historical minorities in particular. And these minorities have, over time, obtained a certain number of guarantees of protection of their cultural, religious, and linguistic identity. But societies in Europe have never been perceived until recently as profoundly plural. So legislation is therefore by the legacy of these relatively homogeneous societies, homogeneous itself. And this situation on the ground has changed a lot over the past 50 years. Actually, there were two developments in particular which are responsible for the ever-increasing diversity within European societies. On the one hand, we experience a growing importance of the principle of non-discrimination of the individual person. But on the other, there are other forms of claims of group-based rights which appear, and they are often, but not always, related to the ongoing migratory movement. They are a consequence of global mobility and pluralization of lifestyles. And the first development, this like individual non-discriminative questions, they have led to a remarkable improvement in the protection of people with physical disabilities, for instance, as you mentioned it, or to a greater sensitivity to the gender dimension. But the second development mentions the claims for recognition of cultural and religious practices. They raise questions which challenges us judges in our daily work because the law doesn't give us a precise answer on how to address them. That law doesn't reflect the new cultural and demographic reality the society in Europe is facing. And we often face situations which, under state law, raise the question of the degree of protection that we as judges can offer in a given context. These may be situations created in the country of origin and therefore issues to be dealt with international private law, for instance. Just to give you an example, when I was working as a family law judge, I drafted a judgment allowing a lesbian Austrian woman to adopt the child of her lesbian female partner. That's quite common. And there was an ECHR ruling that Austria had to improve its legislation, like in this regard. So for me, it was kind of easy to draft this judgment. A week later, I had the exact same case with the exact same facts, except that all the three nationals, the two mothers and the child, were of Polish origin. And under international private law, I had to apply Polish law. And the Polish law didn't foresee the opportunity for a lesbian mother to have her child adopted by her lesbian partner. So actually, I was even trying to find a solution by looking at the jurisprudence of the ECHR. But actually, there was no way. I had to apply this Polish law. And so the outcome was that my Austrian case had to be solved completely different from this Polish case. And likewise, we often encounter criminal cases which, even if they seem to be very clear-cut at first sight, evolve into a problem of a cultural dimension. Imagine you're a public prosecutor and the woman working at the kindergarten comes to you and reports that a child, a 4-year-old child, has reported on several occasions that his father always kisses his penis in the morning. So there are great chances that this father is going to be a suspect, if not an accused, in a criminal case for having sexually abused his child. So now you imagine you're in the trial and you're the judge, and it turns out that this father is of Albanian origin, and he can prove that in Albania it's normal to appraise the genitals of male descendants by kissing them. And you hear a cultural expert who confirms that this is the case in an Albanian community and that this father stems from this Albanian community. How would you then solve the case? So likewise, the mutilation of the human body, for instance, might pose a problem under the criminal law of your country, even though in other cultures it is not identified as such. And if we go back to family law, principles of child rearing pose a problem whenever they do not align with our view of what's the best interest of the child. Just to cite a few other examples. Unregistered religious marriages usually pose a problem. Family business that does not comply with employment law. Inheritance regimes that discriminate on the basis of sex or religion. Matrimonial arrangements that are really to the detriment of women and put women in a great disadvantage. Early marriages or requests from parents to exempt the child from certain parts of the school curricula. Requests to express one's own religion at the workplace. So to what extent are we, as deciding judges, obliged to take such cultural explanations into account when deciding our cases? So I hope that with this little excursion to this scientific approach to answer the question, as well as to my experience that I had, I could give you an idea of what cultural diversity is, in my opinion. Thank you.
Thank you very much. And it was not so long. It's okay. It's very interesting. You have made very interesting reflections and very challenging to make us think of how wide diversity may be and how difficult it could be to make a comprehensive approach to it all. And the answer or the red flag is fundamental rights, as you have said, and I think we all agree. And that thought takes us back to the beginning of the table again, and to look to you, Gianluca, and this new approach you made to design the training on fundamental rights. Could you explain us what are the specificities of this new approach like, and how has it worked? Yes.
Oui, merci. Merci beaucoup, Abigail. En général, un peu suivant les sujets qu'a traité Katharina, l'approche sur la différence culturelle, c'est très important, je le dis. Mais il faut les connaître, il faut appliquer, il faut discuter, mais il faut faire attention à arriver à un certain point. Parce que le risque, c'est d'accepter tous. Alors, s'il y a quelqu'un qui mange les hommes, et je ne peux pas accepter dans les systèmes italiens, on ne peut pas accepter quelqu'un qui mange les hommes. C'est très important de connaître, faire des applications, mais il y a bien sûr des limites, même internes, non, du contexte international. Par exemple, la polygamie. Bien sûr, c'est la culture arabe, mais c'est quoi? En Europe, on peut accepter la polygamie je ne sais pas, doucement, doucement, hein, parce que les choses et l'innovation sont très importantes, mais il faut faire attention. Même pour... il faut préserver un peu les racines communes. Hein. On n'arrive pas d'un espace vide. On a une tradition, mais il faut combiner. Bien sûr, innover. Innover, c'est très important. On est ici pour discuter, mais il faut faire attention, bien sûr. Alors, les formats, c'est très simple. Je dirais, on a des personnes spécialisées dans certains domaines, par exemple la violence contre les femmes. On demande à tous les chefs des cours d'appel d'Italie et au premier président de la Cour de cassation, au procureur général, d'envoyer un magistrat spécialisé dans les domaines. On met tout ensemble des jours de discussion, un après-midi et le matin suivante. Le premier jour, il y a des experts qui portent sur la table les vrais problèmes qui sont liés à chaque question. Par exemple, pour l'Italie, les mesures de protection des femmes préventives, bien sûr, avant les délits et les langages, par exemple, dans les arrêts, de la violence contre les femmes. Après, il s'ouvre une discussion ouverte avec les participants. On va clôturer la session. Les matins suivants, il y a des workshops, des ateliers parallèles avec de 20 personnes, avec deux facilitateurs. Un qui arrive de Strasbourg et l'autre qui arrive du niveau interne. Et comme ça, on discute sur les sujets qui ont été posés les jours avant. Et à la fin de la matinée, tous les experts, les facilitateurs, les coordinateurs arrivent à porter les résultats, hein, qui ne sont pas seulement des critiques, mais il y a beaucoup de bonnes pratiques qui peuvent être soulignées dans la discussion finale et dans les rapports. Ça, c'est très important, avoir le rapport final qui est envoyé. Et ça marche, je dirais, parce que les effets, les réponses sont très positives, hein, et aussi le comité des ministres du Conseil d'Europe a mis cette pratique dans les bonnes pratiques, dans les rapports annuels du Conseil d'Europe. A été souligné la relevance de cette approche de l'école italienne. Mais on a utilisé les mêmes formats, même pour des autres sujets. Pas seulement, par exemple, par les problèmes liés quelquefois à l'immigration, ce sont toujours des sujets qui devront être considérés avec une certaine attention, mais aussi dans les droits de la famille en général, mais aussi dans des autres domaines comme les droits bancaires, par exemple. Parce que l'idée, c'est de créer vraiment des occasions, des discussions intenses sur plusieurs sujets, mais avec des personnes spécialisées qui représentent toute l'Italie, tous les pays, tous les niveaux, juges du fond, mais aussi Cour de cassation, légitimité. Et je dirais une dernière chose, même pour les OECD, il y avait, vous savez que maintenant l'Autriche, non? Katharina me disait dans l'autobus, dans les pullmans, qu'il y avait une évaluation de l'Autriche sur les niveaux, ce sont des évaluations périodiques. Il y avait un rapport sur l'Italie, sur la corruption internationale. On a fait un séminaire similaire sur le même format, avec une discussion avec OECD, avec des experts, pour considérer les résultats de l'évaluation de l'Italie. Et après, on a fait un rapport très spécifique et on l'a envoyé au OECD pour démontrer qu'il y a une réflexion sur le sujet. Je pense que c'est une approche intéressante, bien sûr ciblée. En général, chez nous, mais c'est un peu partout par l'Europe, il y a la liberté de choisir les cours, considérant ce qui m'intéresse, considérant bien sûr les fonctions que j'ai. C'est libre, plus ou moins l'application pour demander des cours plutôt qu'un autre. Mais en allant en parallèle, on sent qu'il y a besoin d'avoir des activités très ciblées pour chercher mettre en évidence ce qui sont des bonnes pratiques, des possibilités de résoudre des problèmes, même des discussions, les nouveautés législatives, ou quand il y a des contrats, des jurisprudences, choses comme ça. Merci.
Thank you very much, Gianluca. And I'm glad to hear and to notice that, well, it's not the same, but it's a similar approach of the agenda of this directors' conference with this roundtable. experts to focus, and then the workshops to debate on some specific topics, not all of them, but so I guess we're on the right path. It's well, and remembering that it's not always what we do to our external publics, but also inside. Wolfgang, could you tell us what are the challenges of conducting a survey like the one you organized, and what are the plans you have for implementing the findings of this survey?
Mm-hmm. Thank you very much. I realized I didn't really answer the second part of your first questions concerning the conclusions, so I want to start with catching up with this. And we have not have the final results yet, but we have a draft of the findings of the first part of the survey that concerning diversity on the staff and the acceptance of diversity. And I will start with the topic of diversity of the employees. And it's very difficult to give numbers in such a format here. So we'll just focus on some key points. And for diversity, that will be the origin, the social background, disabilities, and religion. And concerning origin, we discovered that we have really something that we need to improve. From all employees, 10 to 20% have a migration background in the parents' generation, but only 5% have a migration background in the first generation. Comparing to the Austrian population, that would be almost 20%. So we have a huge gap here. Concerning social background, we did not ask about income, but we decided to ask about the rate of academics in the parent generation. And we saw that it reflects quite well the Austrian population. And there is this myth that judges and prosecutors are always from well-situated families and the children of judges become judges as well. But we discovered that only 8% of all employees that participated in the surveys had parents that, or at least one parent that worked already in the justice system. Concerning disabilities, we found out that 5% consider that they are affected by some sort of disability. And what is really interesting, that only half of these people told the employee about their disability. Mm-hmm. And from this 50% that have not told the employer about it, 45% said the reason is that they don't want to go public with the disability, or they are even afraid of disadvantages when doing so. So that is a big issue that we have to tackle. And concerning religion, there is, I think, this stereotype that judges and people in justice system are very conservative. But we found out that we have slightly more people even without confession than in the Austrian population. But we have significantly a lower rate of people with Islamic belief. That is very significantly. And to the conclusion concerning attitudes towards diversity, well, we ask a series of questions that were concerning the acceptance of diversity in organizations. And it showed that in general, the participants showed a higher diversity acceptance than in other organizations. But in another questions, 85% said the overall topic diversity is very important. But at the same time, 44% answered the question, this topic gets too much attention through that survey with yes, rather yes, or partly. So we see that the topic is rated in general important, but there might be some social desirable response behavior in that. Since 44 say that even through that survey, this topic gets already too much attention. And last, for this context, very important, concerning training towards the topic diversity. 20% say they have already participated in a training concerning diversity in the last 5 years. 20% say the topic is completely irrelevant for them. 30% say the reason they did not participate were a lack of time. And 20% the training offer was not good enough or suitable for them. So what we see here that we have still some potential by further developing our training offer, but there's a group that we'll probably never reach with our training offer because they are not interested in diversity at all. But we have a potential of 40% of all employees that we can still reach by convince them that this topic is important enough to spend their, of course, really very limited time capacities. And for the challenges, of course, with services crucial participation, we're very lucky to have the backing of our minister, and we were able to set several reminders on the internet. We were able to send emails to all employees. We had the backup of the court presidents and head of prosecution officers to promote this survey. But I have to say that it's a very time-consuming task to design and implement this survey, since you have really to tailor-made the questions for your own justice system. You have to find control question to filter out this social desirable answer behavior, and you have to ask everything you need to know, but at the same time keep it as short as possible to avoid a huge dropout rate. And for implementation, we're waiting on the finals of the final results. And with these results, we will, like I mentioned before, try to filter out some strategic goals that we can work towards too.
Thank you very much. I've found it really interesting, and I thank you for coming back to the conclusions on the first question, because I think you have in Austria you have come to the roots to see if there is a gap or not, if there are gaps or not, and you have found that yes, there are gaps, and our direct users, the judiciary, court staff, are not similar to the rest of the society. So what is happening here? And it's very interesting. Here at INSTEC, we have developed a program of grants to attack the social and economic gap in the access to the judiciary and some professions, but I think it's very interesting the way you have started before. So congratulations. Jean-Philippe, now your turn again. I wanted to ask you about, it's so quite similar to the question, to the previous question to Wolfgang. How are you evaluating the impact of the actions you are developing and that you have explained us before?
Certainly not as well as the Austrians. That's
I'm not sure.
But I am. And also for a simple reason, which is that evaluation is a difficult topic, a challenging topic for an institution like ERA, which operates in a horizontal and transnational, with a transnational character. It's the same for EJTN, in fact. And indeed, evaluation, measuring the impact of what we do is sometimes difficult. So we do, of course, the happy sheet. Are you happy or not? How was the coffee? Did you like the speakers? We'll do that. But in fact, and here I agree with you. I mean, we have, and as I mentioned, we have this need to do it better and properly. We dealt with the topic of equality law for more than 20 years now. We had our first project in 2003, and as I mentioned, we will reach simply on gender and equality, anti-discrimination law simply on that, but there are many other topics where we address diversity. Simply on these two, over to 10,000 by the end of the legal practitioners by the end of the year. So what we did recently, we underwent midterm surveys on the midterm effects of this training, and it helped us to assess whether our participants had improved their knowledge, increased their skills, changed their attitude due to the training. So we asked them many questions. In that respect, my institution learned a lot from the members within the work of the Judicial Training Methods Working Group with the different levels of Kirkpatrick's and so on. Yeah. And to our surprise, this survey, which the last one we did in 2018, already a long time ago, but I mean, we always have the excuse that there was COVID in between. This is the standard excuse. I'm using it.
It's a real gap.
Yeah. And for that one, we managed to get roughly 40% of the replies. So I mean, we addressed people who had taken part in our activities between 6 months before and up to 2 years, I think, before the training. So I think sufficient time not to forget that they had followed the training, and sufficient time to see if they had applied what they had learned. And what was we saw that the impact was quite positive at individual level, but when it comes to pass it on to colleagues and to that was, I will not give you the percentages, but that was bad. So here at individual level, it seems that we are very pleased and proud that we know that some of the judges applied some of the rules because they took part in some of our training, but I'm not sure they talked to you afterwards at institutional level. And we are planning another big survey in that respect, midterm survey, by the end of 2024, and maybe we will see what were deficiencies of the previous one to make it better. So.
Thank you very much. Have you finished?
I'm done because
okay.
I think the challenges at the end are very interesting.
Thank you very much. It's it's very difficult to evaluate. I agree with you. And I understand it has to be more difficult for an institution like ERA, but even at the national level, it's quite difficult for us. And not only with a small survey, you say, did you like the opponents and so on. And there's something we repeat many times, that we don't offer training as if we were making screws or any other thing. We organize and design training with an objective, to make a difference, to generate an impact in the attention in courts and so on. And it's very important to make studies, to make surveys as you have done, and to think forward as the Escuela Superior has also done. Katharina, to end with the individual questions, you have explained us before, from your experience, how should we understand diversity? And how do you take the approach to cultural diversity courts? What do you think is needed to be taken into account when we are working in the court?
Well, I have to say it now, because I'm the activity coordinator of this seminar.
Yeah.
But of course, my approach changed a lot when I started to participate and to organize the seminar on cultural diversity, and I strongly advise you and invite you to participate in it. Because what actually happened, and what my new approach to cultural diversity is, I became aware of the fact that there is a cultural dimension in a lot of cases that I'm dealing with in my everyday life as family law judge. I wasn't aware of that, to be honest. I knew that, like, the district where I was working with was very diverse, like it's in the other region of Vienna, and there's a lot of migration. But I wasn't aware of, like, the whole cultural dimension. Because as I've mentioned before, we know that there is a lot of regulations and there has been a lot of development with regard to this attempt to prohibit the discrimination of individual persons. So one approach actually could be to draw a lesson from these attempts to stop the discrimination of individual people and to let yourself expire, for instance, on how gender or physical disability discrimination is being solved. But drawing from this comparison is anything but straightforward, because the reason is that physical disability, for instance, or gender are objective criteria, or at least they can be objectivized. I don't know if this is an English word, but I hope you know what I mean. But a cultural belonging is something very subjective. So at the level of proving evidence, like finding evidence and proving the facts, it's very difficult. And this is actually where my approach changed a bit. And I tried to be open to cultural expertise. I've never been aware of the fact that I could actually invite a cultural expert to my hearings. I mean, would you have thought of inviting a cultural expert in this case that I illustrated before, where this Albanian father kissed the penis of his son? So I think for me, if I had the file on my desk, maybe it would be a very clear case for me, not very nice to rule on, but when I read it and I have evidence, I think, well, that's an easy one, you know? But then this cultural dimension comes in. So my approach actually is to be less biased, to be more open, and to be more aware of this cultural dimension. And the seminar that I'm organizing helped me a lot in this aspect, because it brings together judges with anthropologists, and the judges have the occasion to talk one-on-one with the anthropologists. And actually, during the seminar, they usually bring an own case to the seminar. And then there is an anthropologist who gives them some inside knowledge on the cultural perspective that is hidden in his case, some ethnological research that this anthropologist has done, or some cultural background information that usually as a lawyer you don't know it because you would have had to study it. And they show ways of how to gather evidence in this regard, those anthropologists. So actually your mind broadens up a bit and you become a little bit familiar with minority communities that you wouldn't have known that they existed. And the experience with the previous training session clearly demonstrated that when judges and anthropologists talk and listen to each other and exchange views, the situation takes a different and more nuanced aspect. And this doesn't necessarily mean that the legal outcome in the end would be a different one. But for the judge, actually, the judge realizes that the applicable law might stand in the way of accommodating a specific practice, belief, or tradition. And at the same time, the judgments could maybe be drafted more sensibilized. So the language, even if the legal outcome doesn't change, maybe we can change the language a bit, because we should draft the judgment for the parties and not for ourselves. And the party usually perceives it herself or himself to be better understood if we address these cultural aspects in our judgments. So the seminar actually enabled me to get this open approach and to take into consideration a cultural aspect, even if in some cases the outcome of my judgment wouldn't change.
Thank you very much. Yes, as we were saying, we do training to be able to offer a better assistance to people in courts. So that's the key point. And we have arrived perfectly on time for the last common question. So thank you very much to you all. Really easy with all of you. Well, I wanted to ask you, all of you, which are, in your opinion, the main challenges that training in attention to diversity faces, and how that we need to deal with them? What are these challenges for the near future, mid-term, long-term? And if you if you think it's okay, we'll maintain the order. So, Gianluca.
Okay. Merci beaucoup.
3 minutes each. That's the only...
Bien sûr, si on va considérer ce que c'est la spécificité de la formation judiciaire, on peut dire que ce n'est pas un passe-temps en hobby, non? C'est quelque chose qui est très important pour aider les juges et les procureurs à jouer son rôle de la manière meilleure, hein, pour la protection des droits de l'homme et pour la demande de justice, bien sûr. Et dans des systèmes comme sont les systèmes civils, bien sûr, d'Europe, où les juges sont professionnels. Il est choisi plusieurs fois entre les jeunes générations des universitaires. Alors, la légitimité, mais la légitimation démocratique, je dirais, d'un juge, c'est dans sa préparation. Et parce que le juge n'est pas choisi par le peuple, mais il a gagné un concours, non? Mais il doit toujours, tous les jours, présenter sa légitimité devant les peuples pour sa préparation. Et on a la probabilité d'un jugement, d'une décision, hein, parce qu'il y a aussi des procureurs qui prennent des décisions, hein, pas des jugements, des décisions correctes, c'est la préparation du juge. Alors, c'est très important ce qu'on fait aussi au niveau européen, parce qu'on échange beaucoup des idées, des pratiques, des bonnes pratiques, comme on est en train de faire maintenant. Hein. Je pense que c'est un début très important de la conférence de nos amis espagnols qui ont organisé ça. Et il faut être ouverte, hein, penser un peu... en anglais, on dirait out of the box, non? Il faut un peu réfléchir. Il ne faut pas être trop clôturé dans l'ambiance judiciaire. Hein. Les juges ne vivent pas dans un tour d'ivoire, hein, même notre institution. Il faut avoir contact avec la société, mais aussi avec les autres professions. Je pense, par exemple, avec les avocats, non? Ou les psychologistes. La société, c'est très complexe. Les choses ont beaucoup changé de quelques années et changent toujours. Alors, il faut rester dans les contenus, hein, dans notre cadre, hein, bien sûr, juridique, mais il faut être ouverte à se mettre en joue. Hein. Je dirais, par exemple, quand Katharina l'a très bien souligné, quand la société, c'est multiculturel, il faut être attentif. Hein. C'est pas, quelquefois, l'interprète, ce n'est pas seulement qui traduit dans une autre langue, mais il doit être capable aussi d'interpréter, non, les contextes sociaux de référence. Ça, c'est très important. Il faut discuter de ces choses dans nos institutions. C'est une approche, je dirais, ouverte. Hein. Et ça, c'est très important. Il y a beaucoup de sujets. Hein. Je pense que c'est un peu la mission de nos institutions, non? De mettre en commun des bonnes pratiques, comme on les fait, je dirais, dans un bon niveau, mais il faut avancer, non? En échangeant ça. Et ça, ce sont des bonnes opportunités pour s'enrichir, pour porter chez nous, à la fin des événements, quelque chose qui peut... même aussi des petites choses, hein, qui peuvent après porter, non, des grands résultats. Non, c'est comme les petites choses qui, après, il arrive et il peut donner des résultats importants, hein, je dirais. Merci.
Thank you very much. Merci beaucoup. Wolfgang?
Thank you. In my opinion, the biggest challenge we'll be facing will be to bring those judges and prosecutors and court staff to diversity trainings who don't have a genuine interest yet. I think a problem is that a lot of people don't really know what diversity means, or have just this faint idea, or just a part of what diversity actually can mean. And I have the feeling that the mindset is, are you pro fundamental rights? Yes, of course. Are you pro equal treatment for everybody and anti-discrimination? Yes, of course. And because I'm not a racist, I'm not a sexist, I'm already quite sensible to diversity topics. And like Katharina explained this before, if we bring judges and prosecutors to diversity trainings, they will then start to reflect and see that they have actually a lot to learn, and there is a way to go for them to actually see what diversity actually means, what categories there are in diversity, and how complex it is, and how much it can help them with the cases. And I think since the mindset is with the staff already, that they are already in a good position to respect diversity, we have to push leadership training in diversity aspects, and maybe even make it a requirement for leadership positions to have done diversity training, because we will only get the staff of the courts and prosecution offices to participate in these trainings if their direct court president or head of prosecution office is promoting it, is standing behind them and telling them this is important. I can tell you from my own experience, you have to hear it from a person that you trust in your close relationship, that is something that you have to work on, and that you don't learn at school or at home. It's something that you have to reflect on and work on actually all your life.
Thank you very much. Jean-Philippe.
No, I'm a bit embarrassed because Wolfgang took my point. So and yours as well. But it doesn't mean that I will remain speechless. So I have I would like to address three more points. Talking about concrete challenges we are facing when the main challenge that training will face the main challenge that training and attention to diversity will face in the future. One thing which is important is also artificial intelligence. Not to forget it. It has the potential to negatively impact diversity and equality. The use of data sets, the algorithm, which are built on prior discriminatory practices, may perpetrate discrimination. So it's important that judges, prosecutors, and all actors in the judicial area are able to identify these issues and understand the technical aspects of artificial intelligence. Therefore, training on digitalization is important. That's the first remark. Second one, which is also when it comes to discrimination, an important point is discrimination is often difficult to prove. And to prove it, judges will need to understand statistics. Statistics to assess whether there is an indication of or even an evidence of discrimination or not. However, this use of statistical evidence is quite complex. You need it involves you have to learn using comparator groups, and so this is a quite complex topic, and this is certainly an area where judges need to be trained. And there was one last remark. I hesitate, but I think I will make it. I would hate me if I would not raise it. So I'm raising it. We see in Europe, in all Europe, a rise of far-right populism. We see in Europe, in whole Europe, a rise of religious fundamentalism, and this has an impact on our society. This has an impact on us. This pressures us. And we should not be weak and think, am I going to address this issue? Am I going to put this on the training of on the program of my training schools? This is a difficult topic in my country or at European level. So there is the risk of a kind of self-censorship. It's not because it's difficult that we should not address it. Mm-hmm. There are difficult topics, and diversity in some of them, even gender equality, which is not the end of the world, is constantly in Europe challenged. So it is our duty to tackle it by being active, proactive, and offering training in this area. Thank you very much.
Thank you very much. Katharina?
Yeah, as I've mentioned, Wolfgang has said a lot of what I actually wanted to say, and I can fully agree that like making people alert that diversity is something they are faced with every day in the courtroom is the main step, and making them aware that this is why they actually need training to know how to address this diversity content-wise in their decisions. But I can also tell you that from my experience, and this is something that I can add on the input that has already been given by my colleagues, from the other way around, I think training is needed. I can tell you that as a young female judge, I have encountered problems which were rooted in cultural diversity, but which didn't have an impact on the content of my judgments. Rather, I made the experience that, especially by male people from certain cultural backgrounds, I wasn't accepted. Because in their countries, women do not work as judges. So they did not only not accept the law I intended to apply on their case because the law was different in their country, but they didn't accept me at all. Mm-hmm. And I think that it's important also to have training in this regard. How can I handle this situation?
Mm-hmm. Thank you very much. In conclusion, and very, very resumed, just talking about the challenges. First of all, we need to understand what diversity means. We need to be open-minded and to think out of the box and not to forget other professionals, especially in our justice world, but also in society in general. We have to be aware of some very important risks we face with artificial intelligence. Has a lot of good things, but we have to be aware of what it means with populism, fundamentalism, and we must not be coward to tackle with all these issues. And well, we should not think that small things are not important because they may have very big results. So I thank you all for your very interesting reflections. I hope you have found the roundtable interesting too, and that it has served as an appetizer for what comes next. Thank you very much also for your sensibility and for all the projects you are boosting in your institutions. And thanks, Gianluca and Jean-Philippe, because it's the second time in a few months we count on you to a table, and we always learn a lot for you both. Thank you very much, Wolfgang and Katharina, because you did not have much time to prepare to come to the table, and you have been wonderful and so generous coming with us. And I always say too many things, but I think it's not a problem. Thank you, Gianluca, for speaking in French. You have reminded us that it's a very important issue. You have talked about languages too. And so I just am like this. Muchas gracias a todos. Muchas gracias. Que ricasco. Moltes gràcies. Merci. Which are the words for thank you in the different languages that are co-official in Spain. And not only, we have something with this subject now in Europe, and it's important to remember that we are different, and that's why we are interesting.